When an incident hits, DORA is rarely the only law that matters. The same event may also trigger GDPR, NIS2, or sector-specific reporting. In this module, we'll look at how to untangle those overlapping rules and design one coordinated, efficient reporting workflow. Financial entities now operate under a dense web of EU rules. Prudential regulations like CRR and Solvency II, sector-specific rules like PSD2, horizontal regimes like GDPR, and on top of that, NIS2. The challenge isn't just the number of laws, it's the overlap. A single cyber incident can trigger several notifications, each with different thresholds, formats, and timelines. That duplication and national variation increase cost and confusion, and they raise the risk of fragmented, low-quality reporting. Lex specialis means the more specific law overrides the more general one. In EU financial services, DORA is that specific law. NIS2 sets broad cyber and network security rules for many sectors, but where DORA regulates the same topic for a financial entity, DORA prevails. In practice, this shapes who you report to, which timelines you follow, and which controls you treat as primary. You don't run two equal regimes in parallel. You anchor on DORA, then only apply NIS2 where DORA is silent and the two can coexist without conflict. NIS2 and DORA sit side by side in the EU framework, but they aim at different levels. NIS2 is broad. It covers many critical sectors and sets horizontal cybersecurity obligations for essential and important entities. Think of it as the baseline cyber rulebook for the wider economy. DORA is narrower but deeper. It applies only to financial entities and critical ICT providers, and it extends beyond security into full digital operational resilience, governance, risk, testing, incident handling, and third-party management. So if you're a financial institution, DORA effectively functions as your sector-specific version of NIS2. DORA and GDPR often light up at the same time, but they focus on different dimensions of the incident. DORA is about system resilience. Can your critical services keep running or be safely restored? Supervisors look at continuity, stability, and the impact on financial services. GDPR is about individuals. Were people's personal data accessed, lost, or corrupted? Data protection authorities focus on rights, freedoms, and potential harm to customers. In a ransomware attack, you often owe both reports. One event, two regimes, with distinct questions, timelines, and stakeholders. PSD2 already required payment providers to report significant fraud and security incidents to supervisors. DORA doesn't discard that logic. It absorbs those concepts into a single cross-sector framework and tightens definitions. For payment institutions, this means PSD2 incident processes can't just continue as a separate track. They need to be refitted so that detection, severity assessment, and reporting all follow DORA's major incident criteria and timelines. Practically, you map current PSD2 fields to DORA templates, close any data gaps, and make sure one harmonized workflow feeds both internal and regulatory reporting. DORA and the EU AI Act also coexist but address different risks. DORA focuses on the ICT risk of your systems, uptime, security, continuity, and resilience of the digital backbone. The AI Act, by contrast, targets high-risk AI models themselves, their safety, bias, explainability, and impact on fundamental rights. So even a platform that is fully DORA compliant still needs separate AI Act controls and assessments for the AI models running on it. Picture your core payment platform going down. It is fixing servers, legal is checking liabilities, compliance is scanning reporting rules. Meanwhile, each regulator and even the public hears slightly different versions of what happened and why. That fog of war is exactly what DORA wants to eliminate. By defining common processes, roles, and reporting lines, DORA pushes you toward one coherent incident story, reducing rework, avoiding regulatory arbitrage, and protecting your firm's credibility. A practical way to handle multi-regime reporting is to build a single incident triage hub. All relevant facts are captured once, then reused for every obligation. First, the hub decides, is this a major ICT incident under DORA? Second, it checks, is personal data involved, so GDPR reporting is triggered? From there, structured outputs go in parallel to DORA competent authorities, data protection authorities, and any required customer or public notifications. This reduces duplication, speeds response, and makes regulatory reporting more consistent and defensible. When an incident occurs, several clocks start at once. DORA effectively forces you to raise your hand first, often within about a day. It acts as the early signal. You set the initial narrative for financial supervisors. GDPR's without undue delay and 72-hour maximum then apply for personal data impact. Your process should connect these timelines so one assessment feeds both regimes. The crucial point is accuracy in that first DORA report. A careful, fact-based early warning avoids embarrassing corrections and helps keep your credibility intact. Under DORA, large cloud and other ICT providers can be designated as critical third-party providers or CTPPs. That's a significant change. These players are now directly overseen by European supervisors, not only through contracts with each financial institution. However, this extra oversight does not replace your own obligations. If a CTPP suffers an outage or cyber incident, they may have to inform the regulator, but you still must classify the incident, assess the impact on your services, and file your own DORA reports. Think of it as shared scrutiny, not shared accountability. Regulators watch the provider, but they still judge you. Under DORA, different teams can no longer afford different meanings of incident. If cyber, privacy, and risk each use their own language, you may miss major incidents or report them late. The remedy is a single taxonomy, aligned with enterprise risk management. Every alert type is classified using shared definitions, impact levels, and severities. Once that's in place, you can automate the chain. A major incident in IT monitoring instantly becomes a major incident for compliance, triggering the right reporting, escalation, and communication steps without debate or manual translation. Incident reporting under DORA is not just a one-way compliance burden. When a financial entity reports an ICT incident, supervisors aggregate those reports across the sector. That lets them see emerging patterns, critical dependencies, and systemic risks that no single firm can spot on its own. In return, authorities can send back tailored guidance, sector-wide alerts, and improved threat intelligence. Your incident becomes a learning opportunity for the wider system. The mindset shift matters. Report early, report well, and actively use the feedback to strengthen your own controls and testing. One way to see your regulatory landscape is as a stack. At the base, DORA is your foundational ICT resilience rulebook for financial services, and it takes precedence over horizontal rules like NIS2 where both apply. In parallel, GDPR continues to fully govern any personal data you process during operations and incidents. On top of that, the AI Act adds extra obligations whenever you design, deploy, or rely on high-risk AI models. DORA is not just another regulation, it's your blueprint for coherent resilience. Unify ICT risk management, incident handling, testing, and third-party oversight into one operating model, not 4 disconnected projects. Use incident response plans that cover all regulatory triggers, tune vendor contracts for fast, accurate notifications, and demonstrate that your controls actually work in practice. Supervisors expect resilience in action, not just well-written documentation.